Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. Today, I'm going to talk about how do you save money in your family law case. And I'm going to give you 10 different options from least expensive to most expensive. So let's dive in. First and foremost, the least expensive, at least in terms of attorney's fees, is to represent yourself, which is known as pro se litigation. So that's not that uncommon for people to represent themselves. I would only recommend it if you have a simplified or very simple family law case. So a simplified dissolution of marriage in Florida is where there are no minor children and where there is no support being paid, either obviously child support because there's no minor children, or alimony. So there's no support. There's probably just a fairly simple equitable distribution in the case, and pro se may well be an option, save you a lot of money. I have seen some horror stories with pro se when they should have had at least some advice from an attorney, maybe just an initial consult, where the other side could have easily paid for their attorney's fees. I've done videos on how the court awards attorney's fees in cases. If there's a disparity in income, the other side has the ability to pay it and you don't. So at least meet with an attorney one time, if at all possible. But the least expensive from just an outright attorney fee situation is to represent yourself pro se. Number two, ad hoc. This is where I'm talking about you can talk to an attorney to get advice from time to time only when you need it. You're not actually retaining the attorney to represent you in the whole case. You are still representing yourself pro se, but you're getting advice of counsel from time to time. So you can meet with an attorney, tell the attorney what the essential facts of the case are, and the attorney will be able to tell you, okay, this is the type of petition you need to file. You need to request certain types of relief, certain types of time sharing schedules, that kind of stuff. That way, not just at the beginning, but throughout the case, when you need that advice, you've got a hearing coming up. What do you need to establish? What do you need to prove? You can meet with the attorney for 30 minutes or have a telephonic for an hour, whatever the case may be, and get the advice you need. All right, number three. Okay, this is what I call a pre-suit mediation or settlement conference. So it's similar to ad hoc, where you ask the attorney to represent you at a settlement conference or even a mediation that is going to be handled before the actual divorce case is filed. That way it's a lot less expensive. You haven't had to file the case. This can be handled before the other side feels like, okay, now I've been served and now there's some expensive litigation that we're going to engage in. It's where the people are more amicable, perhaps at the beginning. This works a lot of times, and sometimes it doesn't. But it is an option that I would say is worth talking to an attorney about. All right, number four, retain the attorney under a limited notice of appearance. So that can be for any portion of the case. This is kind of the next step. You may have been getting some ad hoc advice from an attorney. They have filed no type of notice of appearance, so the court doesn't know they're necessarily involved in the case at all or giving you advice. This is beyond the pre-suit mediation or settlement conference. This is now the lawsuit, the divorce action's been filed. You've asked the attorney to enter a limited notice of appearance for some aspect of the case. It might be just for drafting the initial pleadings. It could be for showing up at the first actual contested hearing for you. I've done prior videos, but you have to go to mediation first before you can go to a contested hearing with the court. But the attorney can actually represent you at the ultimate trial with a limited notice of appearance. Now, most attorneys, good attorneys, are going to require that there's financial affidavits filed in the case because the court's going to require it. Mandatory disclosures been exchanged so the attorney can know what assets and liabilities are out there and see the documentation to establish whether the financial affidavit is accurate. So you want an attorney to actually do their job and to make sure that everything is done correctly so that at the end of the case, you can kind of rest assured and know that everything was done right. The next step, number 5, is actually go ahead and retain the attorney. It's not a limited representation. This is a full representation. This is where you provide the retainer or positive trust balance. There's a difference between those. I believe I've done videos on that also. And your attorney should seek to resolve the case pre-suit. In other words, you can retain the attorney, and before the actual divorce pleading or petition is filed, the attorney can reach out to the other side with a proposed marital settlement agreement or a proposed parenting plan if you have minor children, so that you can try to get things resolved amicably up front before everybody thinks, okay, we're in litigation and we're gonna go to town on this thing. So that can save a lot of money trying to resolve the case up front. All right, number 6, if the other side will not entertain a settlement proposal early on in the case, then you're going to need to move forward with the case. And so you filed your petition, they filed their answer, and maybe a counter petition, and you filed your answer to their counter petition. So your pleadings are kind of getting set. You're exchanging mandatory disclosure, filed your financial affidavits, and now you're ready for mediation. So this is the uncontested portion of the case. It's where the case can be settled before you ever see a judge, because a judge doesn't want to see the parties until after they've been to mediation. Why? Because about 80% of cases will settle at or before mediation. And so that can save you a lot of money. Number 7, I'm going to insert collaborative here. So I've talked a lot about collaborative law. There's a ton of benefits of collaborative over the litigation model. But in this video, I'm just talking about expense. And in collaborative, you have a collaborative attorney on each side, and then you have a mental health neutral and a financial neutral. So you do have a team of 4 professionals. So there is some level of expense. Won't deny that whatsoever. And also collaborative depends on the number of collaborative team meetings that you have. So the more meetings you have, the more expensive. Most collaboratives will take 3 to 5 meetings. I've done them as short as 2 meetings. And I think the longest I've done is 6 meetings. So it really depends there on how many meetings you have, what the expense of collaborative. I'm going to say that if you're able to resolve the case by a marital settlement agreement and or a parenting plan before mediation, then it's probably going to be less expensive than a collaborative case. But collaborative is certainly going to be less expensive than a contested case, which is number 8. So with a contested case, that means you've been to mediation, you've filed all your mandatory disclosure or your financial affidavit, and all the pleadings have been filed and discovery's been conducted, and now you're in the contested mode. This is the first time you're going to be able to see the judge, and the judge is going to be called upon to make a decision, and that's where you have to be prepared with your witnesses, all your evidence, and so forth. So yes, it starts to get pretty expensive at this point. I said 80% of the cases settle by the time of mediation. Well, another 15% of cases will settle in the contested phase, but that may be well after the first couple of hearings. It just depends, so that the vast majority of cases settle before option number 9, and that is trial. Trial is the most expensive part of the case. Trial is where the whole dog and pony show happens. That's where all of your witnesses come together, all of the evidence comes together. You have maybe a day of trial, maybe 2 days, and then the court is going to have to make a decision at the end of that. It's really out of your hands at that point. Collaborative would have been far better, most likely, because you would have had much more say in the final result of the case. But you've gone through the litigation model, and now you're fully into the trial phase and the most expensive part of the case. I told you that there are 10 levels or 10 options. Well, there's actually one beyond trial. And everybody's like, well, what could that possibly be? Well, believe it or not, in family law, there are oftentimes ongoing litigation after trial. That could include an appeal or more than one appeal. It could include post-trial motions for contempt to enforce. There could even be post-trial modification petitions, and that's beyond just a motion, like for contempt or to enforce. That's like a new lawsuit. It's called a supplemental petition to modify. You're looking to change the time sharing schedule or some other aspect of the case that's permissible under the law. So it doesn't mean in a litigation model, in a family law case, that you're done even after the trial. Unfortunately, the case can go on, and that's another reason why perhaps collaborative would have been a better choice in your case, unless you could settle it early on. Okay, so those are the different levels or options. It gets progressively more expensive as you go from option number 1 through number 10. I hope this is helpful. I hope it helps you make a decision of what to do. You should certainly at least consult with an attorney early on so you don't miss something really big if you're going to represent yourself pro se. All right, thanks so much. Please hit that like button, that's subscribe to the channel. Would love to have you part of the channel. Please share this video with somebody if you believe it would be of help to them, and leave me a comment. And let me know if there's any other videos, any other topics that you'd like to hear me talk about in the future. Thanks so much, and I'll see you next time.